In the last section, we focused on the buyer attachment, which educates and protects before an offer is written. Now we move into page 1 of the Residential Resale Real Estate Purchase Contract. This is where advisory language transforms into enforceable obligations. This is where the transaction becomes specific, measurable, and legally binding. Page 1 is foundational. If this page is written incorrectly, everything that follows is compromised. In the Phoenix metro market, where offers move fast and competition is intense, precision matters. Errors here can lead to escrow delays, title disputes, financing issues, or even litigation. This section connects directly to professional conduct requirements under AAC R428-1101 and broker supervision obligations under R428-1103. Every blank line is a liability point if not handled carefully. Buyer and seller identification. Contracting parties matter. The contract begins with identifying the buyer and seller. This seems simple, but it is one of the most litigated areas in contract enforcement. A contract must clearly identify the parties to be enforceable. Phoenix example. A property in Mesa is owned by a trust. The agent writes the seller's name as the individual trustee only, without referencing the trust. Escrow later requires a correction because title is vested in the trust. This causes a delay and possible amendment. If the seller is a legal entity, accuracy is critical. Incorrect party identification may create enforceability issues. This is particularly relevant in light of increased federal transparency and entity scrutiny in 2026 transactions. As a brokerage policy, agents should always verify vesting through the preliminary title report before drafting the contract. Property description, address, APN, legal description. The contract requires the premises address, assessor's parcel number, city, county, zip code, and legal description. While the street address is commonly used, the legal description controls in the event of a discrepancy. Arizona follows long-standing property law principles that the legal description governs over informal identifiers. If there is a conflict between the address and the legal description, the title will rely on the legal description. Scottsdale example. 2 nearly identical addresses exist in a gated community. An agent mistakenly enters the wrong lot number in the legal description. Escrow catches the discrepancy before recording. If missed, the wrong parcel could legally transfer. This is why page 1 demands attention to detail. Full purchase price, structure and clarity. The contract states the full purchase price and breaks it down into earnest money loan amount, additional down payment seller, carryback if applicable. Other considerations. Clarity here protects both parties. The numbers must reconcile. Escrow will balance to the penny. Chandler example. Offer states $600,000 purchase price, but line item totals equal $595,000. Escrow must issue an amendment. Delay follows. Always reconcile math before submission. This is a contract writing discipline. Earnest money, form, delivery, and consequences. Earnest money is more than symbolic. It demonstrates good faith and becomes the central remedy in the event of breach. The contract specifies form of earnest money, check, wire, other, where it will be deposited, escrow or broker trust account, consequences of failure to deposit material breach if closing funds are not delivered. If the buyer fails to deliver closing funds and does not cure after a cure notice, the earnest money may be forfeited. This ties directly to Section 7A cure procedures and breach enforcement. Gilbert example. Buyer fails to wire the down payment on the COE date. Seller issues cure notice. Buyer does not cure within the contractual period. Earnest money becomes subject to forfeiture. This is why educating buyers about timelines during page 0 was critical. Now page 1 enforces it. All cash sales, proof of funds requirement. If the sale is all cash, proof of funds must be attached. This protects sellers from accepting illusory offers. In competitive Phoenix neighborhoods, listing agents often require proof of funds before even presenting the offer. A failure to attach documentation weakens negotiation strength. Close of escrow, recording controls. Close of escrow occurs when the deed records at the county recorder's office. This is critical. Signing documents does not equal closing. Funding does not equal closing. Recording equals closing. Maricopa County practice confirms that recording time controls the transfer of title and risk. If the recorder's office is closed, COE rolls to the next business day. Possession is typically delivered at COE unless otherwise agreed. Pre-possession and post-possession carry risk. Brokers are instructed to recommend independent counsel regarding insurance and liability risks tied to occupancy changes. Tempe example: buyer receives early possession before recording. A water leak occurs overnight. An insurance dispute arises regarding the timing of insurable interest. This is why professional consultation is recommended. Addenda incorporated, contract modification structure. The contract lists addenda that may be incorporated. Additional clause: buyer contingency, domestic water. Well, HOA, lead-based paint disclosure, loan assumption, on-site, wastewater treatment, seller, compensation, seller, financing, short sale, solar addendum, other. Checking the correct addenda is critical. Failure to incorporate required addenda may invalidate negotiated terms. Queen Creek example: property served by a septic system. On-site wastewater treatment addendum not checked. The buyer later disputes septic disclosure compliance. Always confirm property characteristics before drafting. Fixtures. What automatically conveys fixtures are items attached or affixed to the property. Page 1 contains one of the most detailed fixture lists in any state contract. Included items typically include built-in appliances, ceiling fans, garage door openers, light fixtures, smart home devices, affixed solar systems, pool equipment, landscaping, water softeners. Arizona law distinguishes fixtures from personal property based on attachment, adaptation, and intent. If it is affixed and intended to remain, it conveys unless excluded. Peoria. Example: seller removes the mounted TV bracket after closing. The contract specifically included wall-mounted brackets. Buyer demands replacement. Contract controls. Precision prevents conflict. Personal property. What does not automatically convey items such as a refrigerator, a washer, a dryer, and an above-ground spa are included only if checked and described. Additional personal property transfers with no monetary value and free of liens. This prevents valuation disputes affecting appraisal or loan underwriting. Leased items are not included. Seller must disclose leased items within 3 days of acceptance. The buyer may disapprove within the inspection period or 5 days after notice. Phoenix example: solar panels are leased, not owned. Seller fails to disclose the lease in a timely manner. Buyer disapproves within the inspection period. Contract rights preserved. This is contract clarity protecting both parties. Why is the legal description more important than the street address in enforcing a real estate contract? Answer: because the legal description controls title and identifies the exact parcel being conveyed. If there is a discrepancy, title companies and courts rely on the legal description. Why does the contract require proof of funds for an all-cash sale? Answer: to demonstrate the buyer has actual capacity to close and to protect the seller from accepting a non-performing offer. What risk exists if leased solar panels are not disclosed within 3 days of acceptance? Answer: the buyer may exercise disapproval rights within the inspection period, potentially canceling the contract or renegotiating terms.